Welcome viewers. Former performing Solicitor General Neil Katyal was once the legal professional who regarded earlier than the Supreme Court to argue in the Moore v. Harper case, and he now not solely got here prepared, he got here organized to go after the justices with their personal words. As we proceed, if you are new to my channel, please take a minute of your precious time to hit the subscribe button and the notification bell for latest updates from uses, the tips for common cause. Katyal walked through the methods in which the Supreme Court inserted itself into the nation legal guidelines after in the past, announcing that they have been leaving legal guidelines up to the states to decide, which is but some other contradiction. That said, the courts claimed states' rights for abortion, however, then blocked it for gun regulation. The change between Katyal and Thomas started with the latter pronouncing that he'd been trying to ask the attorney questions for 30 years, drawing laughter from the court crowd. Katyal fired back. "I've waited for this case for you due to the fact it goes to precisely how you interpret the Constitution, with history." He went on to give an explanation for how the records of the courts suggest simply how incorrect the Republican facet is. You stated this courtroom commonly would not second-guess nation courts' interpretation of their very own constitution, stated Thomas. Would you say that in the case of Baker v. Carr I do not assume you declare it unconstitutional? Any range of things. To say they received their very own constitution incorrect is simply a depend of interpretation. That is, Katyal stated as Thomas interrupted. It was once merely an interpretation of their personal constitution, stated Thomas. In violation of federal law, stated Katyal. Yeah. In the end, it was once invalidating their interpretation of their redistricting principles, stated Thomas. And Justice Thomas, it is the equal factor selecting up on Justice Kavanaugh's questioning. Palm Beach, the courtroom stated that sovereignty used to be at its apex when speaking about kingdom constitutions and interpretations through kingdom courts, stated Katyal. Let me ask you this, Thomas stepped in again. It can also be a bit unfair. If the kingdom legislature had been very generous to minority voters in their redistricting and the country Supreme Court docket stated beneath their country charter that this used to be, it violated their personal kingdom constitution of North Carolina, would you be making the equal argument? Yes, Katyal said. Justice Gorsuch stated it looks as even though it relies upon even though it depends on what ox is being gorged. You would be making the equal argument? Thomas requested again. This court by no means second-guessed country interpretations of their personal constitutions, Katyal explained, returning to his argument that the court has in no way long gone to combat with the states like this before. If it is a familiar clause and it advantages or hurts minority voters, Justice Sutton says this is the system the states deal with. There is an extraordinary guard right here, which is the 2d1/2 of the elections clause, which lets in Congress to supplant something that errant country selection is. What is the supply of the authority for the country of North Carolina's Supreme Court to be worried in a federal election? Thomas asked. I apprehend there may be no disagreement about a kingdom legislature, however this is a federal election, and it is comparable to the trouble we had with the presidential election in Bush v. Gore. Bush v. Gore had a provision in it that stated it would solely observe to that case and must in no way be used as case law. Your Honor. It's the actual equal thing. It's a federal issue. The North Carolina court docket is decoding the elections clauses and powers, and the query is whether or not or no longer they have misinterpreted or no longer, and so I assume it's the supply of the substantial, alleged major violation here. The spirit of your question, for 233 years, this court's by no means gotten worried and said, hey, we're going to, say the North Carolina court docket bought it incorrect, or their provision was once too summary for enforcement or whatever like that. Rather, this court docket has constantly stayed on the sidelines, let the nation manner unfold difficulty to that different section of the Trident check, Congress, in the 2d1/2 of the elections cause. Please kindly drop your comments about this video below and thanks for